Good morning in the US and good afternoon in Europe. Today we have a match. This is the second quarterfinals match of the Inter-University Law Debate Tournament 2025, 8th edition now. So two teams who qualify from the 8th of finals. We have the University of Bologna in Italy and the University of Maryland in the United States of America. These two teams have received a topic, and this topic is again from a different legal theme. And before we move to the topic and to the debate, of course, we'll ask each team to introduce themselves, the members, and after we'll, of course, do the randomizing of the positions. So we'll ask Mr. Joshua Hale. Welcome. Can you introduce yourself?
Hi, everybody. I'm Josh. I'm a resident third-year law student here at Maryland.
Thank you and welcome. We have as well Mr. Molinelli Gonzalez. Welcome.
Hello, everyone. My name is Jose Molinelli. I'm from San Juan, Puerto Rico, and I'm an LLM student here at the University of Bologna.
Welcome. We have as well Miss Amanda Leong. Welcome.
Hi, everyone. Good morning from Washington, D.C. My name is Amanda. I'm a second-year Juris Doctor candidate at the University of Maryland, and I'm really pleased to be here. Thank you.
Thank you and welcome. We have as well Miss Gulekan Ildis. Welcome.
Hey, everyone. It's so glad to be here. My name is Güleycan, and I am second-year master student from University of Bologna.
Thank you and welcome. We have as well Mr. Gabriel Gever.
Hi everyone, I'm Gabe. I'm a second-year law student at the University of Maryland. Looking forward to a great match.
Thank you, welcome. And we have Mr. Bayramov. Welcome.
Hello everyone, I'm Mahmoud Bayramov, a first-year master student at the University of Bologna.
Thank you. And we have the presence as well of some coach in the room. So we have first Miss Elena Feinib in Maryland.
Hello, I'm also a third-year JD candidate here at University of Maryland. Very excited to watch the match today.
Thank you, welcome. And we have one of the two coaches, Mr. Salahuddin Shkari, who participated last year. Welcome.
Thank you very much. Hi, everybody. I go by the name of Salah. I'm a second-year LLM student here at the University of Bologna. Excited for this one.
Thank you, welcome. And we send greetings as well to the second coach, Miss Elisaveta Vorobey for the University of Bologna, who participated last year, who will probably watch or is watching maybe on YouTube. So, for this match, we send as well greetings and we thank the three judges who will be watching and rewatching the match of today. So many thanks for your time, and of course we'll be welcoming your grading rubric as soon as the match is done, in order to prepare, of course, semi-finals as well. The topic which was sent to the two teams 7 days ago was environmental damage should be compensable, even in the absence of direct human injury or economic loss. So now I will share my screen, so we'll see the randomizer on this screen. Okay, up. So normally you should see a wheel with the double flags and logos of your respective institutions. There are two chances, one chance to be in favor and one chance to be against the motion. So I'll activate now, up, the randomizer. The team will be in favor will be starting the first introduction. So for this match, that will be the University of Bologna will be in favor of the motion, and will be starting the first introduction. And as a consequence, it will be the University of Maryland will be against the motion. Concretely, it means that the University of Bologna will defend the position that environmental damage should be compensable, even in the absence of direct human injury or economic loss, while the University of Maryland will defend the position that environmental damage should not be compensable, even in the absence of direct human injury or economic loss. So now you will have 5 minutes to review your notes, and then we'll hear the introduction from the team from Bologna. So we are done with the 5 minutes of preparation, so I stop sharing my screen. And before we start with the introduction by the University of Bologna, I remind that when you see the yellow card, it means you still have 30 seconds in your speaking time. You can continue to speak, of course. And when you see the red, it means you need to stop, otherwise you might be penalized by the judge for going over the time. So now, I give the floor to the team from the University of Bologna for your introduction. You have 4 minutes.
Am I audible?
Yes, you are.
Ladies and gentlemen, imagine the Earth taking the stand, suing for irreversible environmental harm. Its evidence? 10 million hectares of forests destroyed every year. 1 million species pushed toward extinction, threats that ultimately endanger us as well. Yet the judge dismisses the case, asking, where is the direct human injury or economic loss? This is the failure of a legal system that overlooks the destruction of the very foundation of life. And to correct that injustice, we are here to argue that environmental damage should be compensable, even in the absence of direct human injury or economic loss. My argument is consisted of 3 parts. First, I will address how environmental harm is real and measurable even without direct impact. Second, there is already recognition to prevent such harm, but it's refused to be enforced. And third, why compensation without human injury is legally and practically possible. Now, let's be clear. Harm to the environment does not need to be visible to be real. We live in a world where indirect harm is just as dangerous as direct injury. Over 11 million tons of plastic enter the ocean each year, threatening more than 800 marine species according to the UN Environment Programme. Let me pose you a question. What is the value of an ecosystem? The UN's Millennium Ecosystem Assessment answers that ecosystems purify our water, regulate disease, and stabilize climate. These are not abstract values, they are quantifiable, and their destruction carries a price tag. Consider air pollution, for example. It is responsible for 7 million premature deaths every single year, according to the World Health Organization. The harm unfolds gradually, but it's no less than real. So we must ask ourselves, why does the law ignore these cascading damages just because it doesn't immediately translate into dollars or visible human suffering? Now, moving to the second part. We argue that there is recognition, but there is no remedy. Let's take a look at the International Law Commission's article on state responsibility. Article 1 affirms that every wrongful act entails responsibility, and Article 31 mandates full reparation for injury. Nowhere does it say human injury is a precondition. And in Pulp Mill's case, before the ICJ, the court confirmed that environmental impact assessments are customary international law. But when states fail and nature suffers, legal consequences rarely follow. UN Clause Article 192 requires states to prevent marine pollution, and 235 confirms that they are liable for failure. Still, enforcement happens only when commerce or human interests are harmed. Even binding instruments like the Convention on Biological Diversity and its supplementary protocol go largely unenforced when only victim is in nature. This isn't due to a lack of law. It's a refusal to act when injured party cannot speak for itself, and that logic would be unacceptable in any other area of justice. Now, to the final part. The idea is not radical. It is precedent. In Costa Rica versus Nicaragua case before the ICJ, the court awarded compensation for damages to wetland and biodiversity alone. The UN Compensation Commission as well ordered Iraq to pay $5 billion for ecological harm after the Gulf War. Not a single human victim was necessary for that claim. So, to conclude our arguments, the law acknowledges environmental harm and has even established precedents for compensation. Yet, the persistent lack of enforcement, despite what is at stake for all of us, shows why it's time to make environmental damage compensable, even without direct human or economic loss. So I ask you this, what is justice if it protects individuals but ignores the environment that sustains them? Thank you.
Thank you very much. Now we hear as well the introduction by the team of the University of Maryland. You have as well 4 minutes.
Am I audible and visible?
Yes, wait. I don't see you for the moment.
Oh.
Yes, now I can see you and you can speak, yeah.
Can you still see me?
Yes, we see you, yeah.
In 2023, the Loss and Damage Fund established at COP28 was hailed as a breakthrough in climate finance. Despite its ambitious goals, the fund today remains woefully underfunded and plagued by corruption. As in Transparency International bluntly stated in its analysis of the fund's shortcomings, quote, corruption lies at the heart of the climate crisis. The fund exemplifies a broader problem. Despite decades of international agreements from the Kyoto Protocol to the Paris Agreement, global environmental destruction continues unchecked. These frameworks aim to protect our planet but fail to hold major polluters accountable. Adding new liabilities without addressing root causes will not work. That is why we argue against the resolution that environmental damage should be compensable even without direct human injury or economic loss. Our first contention is that compensating environmental damage without clear human or economic loss is impossible, and attempting to do so would overwhelm an already tenuous existing liability regime. Even when courts recognize environmental rights, they revert to economic metrics. In the 2018 Costa Rica versus Nicaragua case that the pro just brought up, the ICJ acknowledged environmental damage as compensable. However, when determining compensation, the court relied on economic loss instead of intrinsic value and awarded just $120,000, widely criticized as inadequate given the damage. Legal experts agree. Calculating damages for pure environmental harm is inherently flawed, and the ICJ in the Costa Rica case decided on an arbitrary reasonableness standard that lacks uniformity. As MP Ram Mohan and L.R. Kinney wrote in the Vanderbilt Journal of Transnational Law, there is no objective way to assign a dollar value to an ecosystem, and no international consensus on how to calculate moral damages. Their article also emphasizes the importance of domestic liability regimes, rather than imposing a one-size-fits-all approach across the globe. Without objective metrics to measure loss, compensation becomes arbitrary that undermines international environmental law's credibility. Our second argument is that the pros liability regime would pump more money into a corrupt climate finance system and distract from solving the root causes of environmental harm. The global climate finance system is riddled with corruption. For example, researchers from the Australian National University have labeled the Emissions Reduction Fund as a, quote, environmental and taxpayer fraud, finding that 70 to 80% of the carbon credits issued do not correspond to genuine emissions reductions, often rewarding projects like planting trees on non-forestable land or preserving existing trees. In 2010, fraudulent traders in the European Union's emissions trading system exploited value-added tax loopholes, which led to an estimated 5 billion euros in losses for European taxpayers. The pro thus incentivizes states to allow environmental destruction, knowing that the proposed liability regime will allow for greater financial kickbacks. Rather than commodifying nature, we should focus on preserving it. The pro seeks to pump more money into a corrupt and failing system that is only reactive to environmental harm, rather than targeting the root causes of unrestrained resource extraction and consumption. As energy historian Simon Pirani wrote for Resilience in 2020, quote, allowing ourselves to be sucked in by the false discourse and the circus of international climate talks only dooms efforts to fight environmental harm. Effective stewardship requires strengthening local legal frameworks, not imposing a one-size-fits-all liability system. Transforming international law into a compensation-based liability system will merely replicate existing frameworks' failures rather than fostering real progress. In conclusion, not only is the pros liability regime impossible to implement, it would fundamentally disrupt already tenuous existing systems, increase money flows to corrupt governments, and distract from real solutions. Thank you.
Thank you very much. So now we move to the first rebuttals. I give the floor to the team from the University of Bologna. For your first rebuttal, you have 2 minutes.
Honorable Magistrates, the main argument that has been presented by the opposing side claims that there is a fact that in one way or another hinders the vulnerability of the particular economic defense and environmental defense system around international law. But they do mistake something which is essential for us to consider, that the determination of compensation does not in one way or another entail the duty of compensation. And what we are discussing in the present is precisely establishing a duty of compensation which is currently inexistent in the particular vacuums of international law when considered concerning environmental liability. And when we speak about state liability and private liability, yes, there is a factor that I agree with them. The fact of the damage is problematically measurable, because when we look at contemporary tort law, we do see that there are problems with measuring what type of damage has been done, if there's been a particular monetary damage, human damage, etc. But what we have to claim is that under the current framework of international law, there are both customary as well as treaty-based elements of duty of care which states can breach, even in the breaching of abstract principles such as environmental protection. And the question is, because of how abstract these principles are agreed upon and how abstract they are even when they're being implemented in the court systems, will we truly ignore liability just because something cannot be compensated? And I will also refute the fact that compensation is not measurable when we do have the Clean Water Act of the United States, the OECD guidelines, and many other instruments that do speak about the measurability of particular damages in the international environmental context. So we must establish that in the current context, what we are truly speaking about is mobilizing a particular set of liabilities for states and private actors because of the duty of care that they have with the environment. Shall we truly ignore it? Shall we leave the environment as an orphan in the international legal system when we need only push the legal system a little bit further so as to assure protections in the context of what every state recognizes as the duty of care with the protection of the environment which nurtures and makes us all live?
Thank you very much. So now we will hear the first rebuttal as well from the team from the University of Maryland. You have 2 minutes.
We agree with the pro that protecting the environment is imperative, and certainly recognize that international agreements do emphasize the intrinsic value of the environment. However, we move beyond the text of the agreements and actually look at the real world. That is why we cannot accept the pro's position. Certainly, even even if the international agreements say the environment is important, when you actually look to how international institutions are adjudicating these claims, the Costa Rica case as an example, even when the ICJ in that case recognized the importance of the environment, used a lot of flowery rhetoric to talk about the importance, they still fell back on calculating damages based on economic loss and human harm, because that is the only feasible way to calculate damages. This is something that international scholars agree on. As Kanaji and Farr wrote for Questions in International Law in 2019, there is no way to calculate the kind of moral damages that the pro wants us to consider. There is no agreed method. That's why they emphasize that domestic liability regimes are far better. The pro mentioned the U.S. Clean Water Act. That's a great example. We should allow domestic states to have liability regimes to regulate companies within their own states. But fundamentally, judges, we don't even have to win that the liability regime wouldn't work. We don't have to win that damages couldn't be calculated, because they're also failing at two levels. One, the cases take too long. In the Exxon Valdez case, for example, the Alaska oil spill, the harm happened in 1989. The money wasn't paid out until 2009, 20 years later. Same thing in Costa Rica. The money wasn't paid till a decade later. The cleanups already happened. The money isn't actually going to helping the environment because such adjudication takes too long. All the money is going for is towards the corrupt states. As Euronews reported on February 11th of this year, the United Nations is worried about billions of dollars being stolen or misused. The money is only going to corruption, not the environment.
Thank you. So now we are moving to second rebuttals. We start with the second rebuttal from the team from the University of Bologna. You have 2 minutes.
Honorable Magistrates, the opposition in one way or another mentions a series of political circumstances around political will and the functionality of states to actually behave in accordance to their own laws. This is a matter of politics, and when we're speaking about the foundational principles of the law, we need not necessarily question the efficiency of the policy of the politicians that need to follow it, rather the integrity of the legal system that it shall be built upon. And as such, our main question here is if environmental damage should be compensable, and I think that they have even agreed by saying that the answer is precisely yes. And it's only a matter of asking ourselves, what is the intellectual argument behind the building of compensation? And precisely, domestic laws and domestic principles can be a great foundation for the international legal system to, in one way or another, decide how to compensate. The polluter pay principle, as established in the OECD guidelines, as present in the Japanese clean water legislation, as present in the Bolivian Rainforest Protection Act, and as present in the Clean Water Act of the United States, are all great examples of what international law can actually do. do. Shall we truly think that because of a diversity of jurisdictions that international countries cannot agree of a particular number of compensation? We must also refer to traditional private law notions about what compensation is. The ancient jurist from Bologna, Paulus, actually spoke that compensation has one main element, and that is for it to be restorative. And much of the money that has actually been garnered by the particular fines, such as the ones that the United States government imposed upon the BP Deepwater Horizon oil spill circumstance, have actually sufficed to mobilize environmental protection and restitution problems. So truly, what they speak about of political will is so variable that it cannot be added as a horizontal definition to an entire problem. In the present, there is an imperative that we mobilize in direction towards approving that environmental damage should be compensable. Such was the case of the Pulp Mills case of Argentina versus Uruguay, where precisely the International Court of Justice determined that such a compensation was possible even in abstract terms.
Thank you very much. So now we hear the second rebuttal from the team of the University of Maryland. You have 2 minutes.
Sorry, am I audible?
Yes, you are.
Yes. Mr. Molinelli asks us to accept the formalist argument that somehow just because the purpose of compensation is a particular thing, we should merely accept it. We should reject this fundamentally. What their proposition is doing is what is increasing the amount of money damages that are going to be given to these ecological disasters, which we think furthers the harm that it actually occurs. They tell you that the principle of compensation is in order to repair the harm that is caused, but I'm going to tell you in my speech why irreparable harm is something that cannot be remedied by money. And secondarily, we will also deal with other things regarding the politics that has come out in his speech. So, Judge, we want to make this very clear, right? The Exxon Valdez oil spill, the Deep Horizon oil spill, is the costliest ecological disaster ever with no direct fatalities. Charitably, the proposition's best case is one where the damages awarded are several $billion instead of the mere 20 million US dollars that were awarded for the compensatory damages alone. This is to say that the punitive damages would also be included as compensatory measures. Even in this case, the best example that the proposition plan would work is that the immediate effects still include the deaths of between 100,000 and 250 seabirds, at least 2,800 otters, and approximately 1,000 animals which are endangered or critically close to extinction. Those animals, those organisms are things that cannot be repaired, cannot be restored ever. Not only that, but my partner tells you about how it takes years, decades, in order to have access to this funding at all. And not only does this funding not directly go to the environment, but who is being paid in those circumstances? It is simply the US government. And if you believe that the Trump administration would somehow allocate this funding to cleaning and repair, you are wrong. But even if they were to allocate the funding to cleaning and repair and actually clean up the oil spill, the mechanisms that are used to clean oil spills and to repair ecological harm are damaging to the environments themselves, leading to further decline. What we don't need is more money being funneled to these governments to further destroy the environment. They are corrupt. What we need instead is a complete reorganization of how we conceptualize ecological damage. Thank you.
Thank you very much. So now reaching the conclusions, we'll hear first the conclusion by the team of the University of Bologna. You have 2 minutes.
Let me begin with a simple question. Must someone bleed or lose money before the law recognizes the harm that has been done? We say no. Environmental damage, even without direct human injury or economic loss, is still harm, still measurable, and still real. The opposing team wants to reframe this debate as a question of technical enforceability and corruption. But that's not the real issue. This debate is about recognition, about whether international law can evolve to reflect the true value of the natural world. They pointed out Coca versus Nicaragua to claim compensation must always be economic, but that case didn't reject environmental harm. It confirmed it. The ICJ awarded damages precisely because the harm to nature mattered. Also, they say compensation is so slow, that systems are corrupt, but abandoning liability because justice takes time is not a solution. It's a surrender. Corruption thrives in silence, not in accountability. If we don't establish a legal duty to compensate, we are not avoiding corruption. We are enabling it. Like my colleague explained, international law already contains the tools that we need. The duty to prevent transpondary harm, the obligation to repair, and the polluter pays principle. We see that the legal path has already begun. We are not creating legal fantasy. We see that environmental harm can be recognized even without direct human injury. So, dear judges, this debate is not about how fast compensation is paid or whether every dollar is perfectly tracked. It's about whether the law dares to see and respond to harm before it's irreversible. This debate is not just about compensation. It is about whether the law protects only what it can immediately see or whether it has the vision and courage to defend the work that sustains. Thank you.
Thank you. So now we hear as well the conclusion on the side of the team of the University of Maryland. You have 2 minutes.
In today's debate, the pro has operated in fantasy while the con has engaged with reality. At the end of the day, there are 3 reasons why you should be voting for the con. The first is that the proposed liability regimes by the pro are not feasible and they don't work. Yes, we agree that the Costa Rica case did on paper recognize the importance of the environment, but the point we made is that the ICJ there still had to rely on economic loss to calculate damages. They had to create an arbitrary case-by-case reasonableness standard because it is impossible to calculate damages based on intrinsic value as the pro would have you. Not only is it not feasible, but the timelines simply mean that there is no benefit to the environment. The money isn't coming until decades after the environmental harm occurs and well after the cleanups have already happened. Thus, the only risk is that the pro creates more money into our second reason why you can vote for the con, which is corruption. The pro has fundamentally failed to answer this argument throughout the debate. Judges, they just ask that you ignore political and technical questions. That is absurd. This is one of the primary issues in scholarship on environmental damages compensation, one of the primary anxieties of Transparency International, of the United Nations, of other international scholars is corruption. Billions of dollars are going to some of the most corrupt governments in the world, and the pro would have you only send more money. Thus, not only is the money not actually helping the environment, the only risk is that it means more financial kickbacks for corrupt governments. This is simply unacceptable, and it is a reason you can vote for the con, regardless of how you feel about the liability arguments. That is why, finally, our third point is that the pro distracts us from the root causes, uncontrolled consumption and extraction around the world. We don't need a reactive liability regime that gives more money to corrupt governments. We need to start tackling the root causes. It is for those reasons that you should vote for the con, and you should care about the political reality and those issues at hand.
Thank you. So we just heard the 2 conclusions. So it means from now you are not under evaluation, and you can breathe, you can relax a little bit after this very energetic and very strong debate. So it was really a pleasure to hear on my side as organizer, and of course we collect for your impression concerning the topic, performance of the 2 teams, and preparation of the topic of the debate. Before we'll be doing a bit of networking to finish the session. So I will ask Miss Liang, what do you think about this match?
I thought this match was really, really great. I think it was very engaging. I think our rebuttals were actually substantively in conflict with one another. I actually really love making principled arguments and formalist arguments, which is why when I heard the second and the third speech, I was like, oh, interesting. That was great. So yeah, I really enjoyed it. Thank you guys so much.
Thank you. Miss Ildis, what do you think about the match?
I really enjoyed during the match. They came with a different perspective. Thank you for sharing that perspective. When I am searching that topic, I never thought from the corruption perspective. That's why it's really enlightened me. Thank you for your efforts, guys.
Thank you very much. Mr. Hale, what do you think about the match?
Yeah, I think that was the most competitive round that we've had so far, and I think it kind of played out how we kind of would have expected, where the pro is going to be, much more about kind of what should be done, and the con is going to the con, just by nature of the topic, is going to be forced to get into the weeds more, have to try and find places of vulnerability, because I think deep down, we probably do all agree that we should probably help the environment. I don't think anyone here is against that. And so I think it makes for a very interesting debate, and really enjoyed getting into the weeds on the topic.
Thank you very much. Mr. Moinei Gonzalez, what do you think of the match?
Oh, I enjoyed it thoroughly, and I'll have to truly compliment the opposing team for their arguments and the way that they formulated them. I'm really happy that we live in different jurisdictions of the United States. We might not have to face each other in court in the future, so that is actually really good. But it was truly an honor, and I'll hope to see all of you again soon.
Thank you very much. Mr. Giver, what do you think about the match?
Yeah, I just want to echo that I definitely think this was one of the most competitive, if not, this was the most competitive round that we've participated in. So thank you to everyone on both sides just for making this so lively and exciting. So I don't have too much else other than what's already been said, but I really enjoyed this and just really impressed with everyone's performance.
Thank you. Mr. Bayramov, what do you think about the match?
So, Laurent, I think we have become experts on environmental law right now because, if I'm not mistaken, this is our third time debating on this topic, on this field of law. But other than this, I'd like to as well congratulate opposing team. It was a really intense and competitive match. May the best team win.
Thank you. Now I will ask the coach, Ms. Feinliebe, what do you think about the match?
Well, wow, what a joy to watch. That was such a rigorous level of debate, of scholarship being brought up. I mean, I think the arguments on both sides were unique and well-researched, well thought out, and well communicated. I really want to congratulate the opposing team on how well written all their statements were. I mean, they were, reactive while also being very emphatic, and I think we certainly tried to put a lot of that into our preparation as well. So congrats to everybody.
Thank you. Mr. Shakiri, what do you think about the match?
It was pretty much said it all, really. They took it from as many angles as they could and, keeping tracks of what they had to say and at the same time what the opposing team said, and that was not foreshadowed during preparation, really shows the quality of both teams' work. And really just the fact that they made it this far pretty much says it all. And I congratulate the University of Maryland for the very good job that they did. And I'm proud of you guys at the University of Bologna for doing the things that you've been doing the way you've been doing. Well done.
Thank you very much. So again, we thank the three judges who will be watching and watching the match during the next 2 business days in order to provide their results, of course, directly first to the teams and then published. So congratulations from the side of the organizers, because you are among the 8 best teams of this year, and of course next round will be with the 4 best, the final 4, let's say. And a last element for this, I would say, session, of course, is the networking. This time, we'll ask questions which are a bit more on your own personal ambition, professional ambition. So these 2 questions are concerning what you want to achieve in your career. What if you would have a possibility to have a project or let's say to work on something, what would be for you your dream to have in your career? And the second question will be if you would have a chance to go or go again abroad for studying, where would you like to go, which university or which country? So the first question I will give to all of you, one by one, of course, and second question afterwards. So we start with Ms. Gaver. Mr. Gaver, where would you like to go what is your personal or professional dream? I mean, for the upcoming years.
No, thank you. Thank you for the question. I guess in the short term, my dream is to be able to get out of debt for 3 years of expensive law school. So I think early in my career, that's sort of my plan. But I think ultimately I am very interested in being a prosecutor, and especially working in the U.S., but also maybe doing some work in international court as well. Just trying to fight for justice, enforce the law, and hold bad actors accountable.
Okay, thank you very much. Mr. Bayramov?
I would like to as well categorize it as short term and long term. For short term, I would say what I want is maybe become a part of international organization. Doesn't really matter which one, but I believe becoming a part of international organization is such a huge experience that every lawyer would like to achieve, would like to experience that. But regarding long-term dream, maybe we can say goal as well, and it can sound a little bit absurd, but what I want to become is maybe head of some division of government. Like I don't know. What I want is to become one of the person that will be memorable for a long time. If I can be clear with that, I don't know.
Yes, thank you very much. Miss Young.
Yes, thank you for your question, Mr. Larange. I think I'm really interested in dispute resolution broadly. So arbitration, mediation. I've actually just been trained as a mediator, so I'll be able to mediate in the courts here in DC and Maryland at the end of the summer, which will be very exciting. But I think broadly speaking, like I'm more interested in international dispute resolution, whether that means mediating peace talks or even perhaps arbitrating. I think that's sort of my goal. So like I have quite an international background. I've lived in 4 different countries. My father was a refugee to the United States in the 70s. And so I think international humanitarian law is of great interest to me. So we'll really just see where it takes us. I think the University of Maryland has a ton of opportunities to explore dispute resolution. And then to your second question, where would I have studied abroad? I'm really interested in the ways that restorative justice work, or like how reconciliation happens. So I think I would study abroad in South Africa, or perhaps Rwanda. My older sister actually lives in Cape Town, so it'd be nice to go see her as well. Thank you.
Okay, very good. Thank you. Miss Ildis.
Thank you for the question. I want to both, in my future life, I want to see combination of practice and theory. First, I would like to continue in academic way. I want to be lecturer in the end. But then at the same time, I want to see the practical area. I am interested in immigration law. That's why I literally want to work with immigrants face to face, or asylum seekers. Also, our friend, Mrs. Liga, mentioned about it. Also, she was interested in immigration law, asylum seekers. That's so interesting, a good point. That's why I want to kind of combine with NGOs and university life. Maybe after getting some practical experience, then I can share also that practical experience in my lectures.
Thank you. Mr. Hale?
Yeah, I'm mostly interested in civil rights impact litigation here in the United States. So really on kind of the 3 areas would be like juvenile justice, prisoners' rights, and LGBTQ rights. So anything along those lines, particularly helping incarcerated people and just harassing United States prisons and chipping away at the evil United States prison industrial complex. Really anything I can do there, that's kind of my goal.
Thank you very much. Mr. Moinelli Gonzalez?
Well, in the short term, as soon as I finish the LLM, my plan is to go back to Puerto Rico and continue working in the domains of criminal and public law that I used to be engaged with. However, in the long term, I do have the plans of taking up a doctorate and hopefully becoming a law professor. And I'm very interested in the realm of legal philosophy and legal sociology, which is the reason why I chose Bologna. But definitely, if I were to have to do a PhD somewhere in law, I would definitely choose Salamanca in Spain, which would be like the hotbed for jus naturalism, which I've become a bit of a masochistic supporter of, although most people are shifting away from that towards positivist ideals. But I'm still a naturalist at heart. So, yeah.
Okay, thank you very much. So now, even if you answer the second question, some of you I will come back as well asking those who did not answer, concerning where you would like to go studying an additional 6 months, for example, abroad. Where would it be, a university or country, Mr. Gaver?
So can everyone hear me?
Yes, yes.
I'm excited, or I had the opportunity in high school to spend 6 months living in Switzerland, and I really love Switzerland. I would love to go back. I was in Zermatt, but I would really love to study in Geneva. I think especially just given the history and sort of the international law reputation, everything that has happened there. I think would be really exciting.
Thank you very much, Mr. Bayramov.
So there is a common opinion in my hometown country in Azerbaijan that if you want to look at law from different perspective, you have to go study in the US. So basically, if I can after finishing my master's degree, my dream is to go to study a PhD in the US. And then I don't know, but living and experiencing the US life that we are seeing in Hollywood movies is also a little bit interesting to me.
Thank you. So Miss Liang, this is for South Africa or Rwanda, from what I understand. Yeah. Thank you. And Miss Yildiz, you did not mention, I think. No?
I didn't mention. Thank you for asking. I agree with my colleague, with Mahmoud, because I think that the common law system gives the lawyers or the practitioners different perspective, because especially coming from a Europe or European region have different legal tradition. That's why it can really good experience to broaden the perspectives.
Okay, thank you. And Mr. Hale, where abroad?
I'll give you two answers. So for one, I was thankful enough in undergrad to go study abroad in Senegal for a while. And I think I'd like to go further south there in West Africa and would love to go to Nigeria, obviously one of the most important and largest countries in West Africa. And then additionally, I've never been to Europe before, and I got family in Germany, so I just like to go there. Although I can't really give you an academic reason for wanting to go. I just like to go to Germany. But that's kind of, those are probably a couple on my mind.
Okay, thank you. And Mr. Mini Gonzalez, so you said after Puerto Rico, or you would somewhere else, or go somewhere else, or?
Yeah, I said that I'd go to Salamanca in Spain, definitely. But it's interesting that we have this discussion, because coming from a US law school, everybody asks me, why did I go to Europe? And when I come to Europe, everybody says they want to go to the United States. So it's an interesting back and forth.
Yes, indeed. So many thanks again. And so the results will be coming, I hope, by the end of this week, of course. So we'll be able, of course, to prepare semifinals and as well send already certificates as well for the other team. And of course, don't forget to watch as well the match of the other quarter finalists, because that might be your future opponents as well. So on our side, I want to thank all of you, because it was a very intense, good start of the week as well, full of energy on this topic. It was very enjoyable, I have to say, and many thanks as well for all the people watching in the US, in Italy, and maybe somewhere else. So very soon we'll have the semi-finals, but first we'll have the two other quarter-finals coming in few minutes, and on Thursday for the two other match. So many thanks in Italy, many thanks as well in the US, and we keep in touch. Thank you very much. Thank you.
Thank you.
Thank you.
you.
It's a pleasure.
Thank you.
Thank you.